Subscribe to our YouTube channel and press the bell icon to get the latest updates.
Hi everyone, I am Bhadra Sinha, Associate Editor with ThePrint, and I welcome you all to a 4-part series of discussion on building a judiciary for the 21st century with the Vidhi Centre for Legal Policy as the knowledge partner. Now this series actually draws on JALDI's extensive empirical research over the last few years with over 30 reports. Let me just tell you what JALDI actually stands for. JALDI stands for Justice, Access and Lowering Delays in India, and this is an initiative at Vidhi. So as far as today's discussion is concerned, it is on accelerating access, and it draws on Vidhi's research on facilitating delivery of justice through technology, specifically through online dispute resolution, and on building better courts. And to throw more light on this subject, we have a distinguished panel comprising eminent speakers. We have amongst us former Supreme Court Judge Justice AK Sikri. Justice Sikri does not need any introduction. With more than 2 decades of experience as a judge, he has authored more than 4,500 judgments. Some of his most notable judgments include upholding the validity of Aadhaar law and on the exact balance of power between the centre, represented by the Lieutenant Governor, and the local administration. Now, while heading a bench in 2018, Justice Sikri also nudged the centre to draft the much needed witness protection program and ordered its countrywide implementation till the Parliament framed a law on this. It's a privilege to have you, sir, with us today. I also welcome Dr. Gaurav Raheja, who is a professor with IIT Roorkee. Architecture and planning. He's very well known for his studies and projects revolving around accessibility. He is a universal design consultant. Professor Raheja has contributed on some important government projects to design more inclusive public spaces. He was the accessibility consultant under the Accessible India campaign to the Government of India for Prime Minister's Office, the New Delhi Railway Station, Delhi's International Airport, and the Central Secretariat. We also have with us 2 eminent scholars from Vidhi, Vidhi Mishra, who's a senior resident fellow with JALDI, and Reshma Shekhar, who's also a senior resident fellow with JALDI. They both are part of the panel today. I welcome both of you as well. Now, with the permission of Justice Sikri, I will open this discussion with a question to Reshma. Reshma, actually, access to speedy justice continues to be a challenge even in the 21st century. Why is it so? And, I would like you to actually highlight some of the important points of Vidhi's survey on the entire judicial infrastructure of the country, how adequate it is or how inadequate it is.
Thanks, Bhadra. So the Vidhi study that you referenced to is the survey that we published in the year 2019. The report is called Building Better Courts. This was a survey that we commissioned for the year 2018 and 19, and we surveyed 665 district courts and also interviewed 10 litigants per court, so around 6,650 odd litigants, based on the metrics and parameters that has been laid down in the 2012 Court Development Systems report that was brought out by the Supreme Court's National Court Management Systems Committee. So identifying baseline parameters from the NCMS report, we designed a survey and commissioned it. And the report was published in 2019, as I had mentioned. So the conversation, as in some of the numbers that came out from the survey, unsurprisingly were something that we really thought is going to be the case, right? But what is also shocking is that the state of the infrastructure of courts in India is very crippling, and it's very dismal. But the conversation around courts are mostly centric around the pendency and vacancy. And along those lines, conversation about infrastructure is also always limited in quantitative terms, in terms of the lack of number of court halls, right? But it's also the qualitative, the facilities within these court premises that need a lot of attention, and that needs to be brought out in the open. So based on the survey results, we know that 20% of these courts that were surveyed, they did not have any guide maps that will help a litigant for navigation. So as we all know, like any of us who've had the fortune to be in a court for whatever reasons, we know courts are heavily process oriented. So from the time you enter the premise, you need to have well-directional, informational signages, etc., to take you from one place to the other. So 45% of these courts did not have any help desks either. So you're a litigant, you're a citizen, or you are on your own entirely to find your way to the courtroom or for whatever service you are there for. 54% of these courts did not have any waiting area. So why this is important is that most part of your, as a litigant or as an advocate, what you would spend most of the time in a court is actually waiting for a case. So on an average, you are there for a court, say 2 to 3 hours as a litigant, or say the whole day as an advocate, you end up waiting. And when you do not have designated waiting areas, like when half the courts in the country don't have designated waiting areas, where do you have to wait for your case to be heard? Another very shocking result that was brought to light was that about only 40% of these district courts surveyed had fully functioning washrooms. What we mean by fully functioning is that they were periodically cleaned and had regular running water facilities, So that was only 40% of the district courts, with about 100 of these district courts not even providing washrooms for women. So in this juncture, it's important to say that it's not just litigants, advocates, right? This court is actually an ecosystem. It's an environment for a lot of people for whom it's their workplace. So we are talking about judges, judicial officers, court staff, registry officials, the peons, the drivers, the advocates, the litigants, and everybody else who comes. So even say for all these, most of these people, we are talking about, these are your environment for the next 6 to 8 hours daily for about 20 to 25 days a month. And these infrastructural facilities is what actually makes your work experience there, as well as your participatory justice either restricting or facilitating based on what is available. And insofar as accessibility is concerned or inclusivity is concerned, when we're talking about persons with disabilities who may be wheelchair ridden or who may be having visual impairments, 27% of these court complexes were the only ones who had ramps. By that we mean ramps at the entry and throughout the court premises, and only 11% of these courts had any visual aid tools. That's tactile payments and rail notices. Again, when we talk about judges or court staff or even other officials of the court who may also be having some form of disabilities or the other, these workspaces are not welcoming or inclusive for them. And for litigants and advocates, again, it's closed out for them. It's not making it at all inclusive or accessible for these persons. 26% of the courts were the only ones that had electronic case display boards at the entry as well as in the courts. Again, most of the times you see that the courts and the corridors are extremely overcrowded. So you have to wait in these waiting areas or in the court corridors for your case to be called. And if you do not have these case display boards, inevitably you end up filling yourselves inside the court, creating overcrowding. So this is what the survey showed, and in light of the current situation that we have, right, and the courts going to fully function in a post-pandemic world or in continuing to be in a pandemic world, basic questions of overcrowding itself needs to be asked. How are courts supposed to maintain social distancing?
Yeah.
Exactly.
To manage the overcrowding of the corridors,
given the lack of space, and then given the lack of hygiene and given the lack of hygienic infrastructure, how do we ensure a sanitized environment, right? And so all of these questions were pertinent to begin with, and becomes even more pertinent in a post-COVID world or a post-COVID area where courts have to fully function. So these are some of the important stats that we had from the survey.
Right. My next question is to Professor Raheja. Professor Raheja, public spaces in India are essentially not public friendly or inclusive. Why is it so? And according to you, how crucial are the elements like landscaping or designing when it comes to developing a public space, particularly when we talk about a court building, as has been pointed out in Vidhi's survey, the amenities that are actually lacking in our judicial infrastructure. So, what according to you is the most crucial aspect when it comes to designing a building?
Well, I think there are a couple of embedded questions within this one large question. And I think public realm, I would first want to make a disclaimer here is that it would be an overgeneralization to say that we do not have too many public spaces which are accessible or inclusive, because we do have some of them. if you see public in public spaces in India, I think it's perhaps for them at least it is accessible. It's yes, I would also agree at the same time, there is plenty of scope for us to intervene, right? On the second side, I would like to bring this perspective because, I come from a discipline which I think needs to be a little more talked about in our country. And it is taking a little backseat in the front conversations because architecture is no longer a discipline of brick and mortar. It's about life and space together, right? So I would say in a very simple term, just as English or Hindi is a language through which we communicate, a built environment is a language of a living civilization, right? So whatever you leave behind, whether it was the pyramids or the Taj Mahal, you continue to decode from history who those people were. Now, our contemporary public spaces, whether you use glass or steel or a broken curb or a beautiful landscape, reflects who we are, what we think is good, and what the priorities are. So I use public space, first of all, as a tool to study the understanding of what the social conflict is. Maybe the social inequity brings us two different challenges in a public space. A public space is a space which is a workspace for a street vendor. A public space is also a workspace for maybe a street sweeper. But a public space is also a waiting space, and a waiting space is many a times misled because it's a transition space. And that transition of 5 minutes, 10 minutes can become insecure, unsafe, and be inaccessible as well for you. And besides that, a public space can also be a permanent space for people like who run their restaurants, who run their shops, around their businesses. So it can be an important economic spinner as well. Now, here I want to bring a discourse here is before I come to why it is not so. So I think why it is not so is a simple word is that the civilization is not understanding and being able to give the right value because there is no collective debate on it. It benefits everyone. It doesn't disturb anyone. Then why shouldn't we talk about it? Is my first perspective. Second thing, when you talk about landscape, I think I was wondering, I mean, I'm not being critical about anything, but right now, for example, we had to put one smog tower in Delhi to take the entire contamination out. No, I was just trying to look at it in this. So of course, it's a way we are solving a problem, spending 20 crores of rupees. But when I'm saying, when you use the word landscape, what is the cost of one tree? And what is the value of one tree is what when one starts realizing something that nature gave us without even charging for a patent, innovation, technology transfer. And we couldn't do that in the name of landscape. What more can I talk about it? It takes the entire carbon dioxide, all your bad particles away. So it has a tremendous value precisely further for a society to come together. So I think that's again a priority. Now the question is, if you don't even leave green spaces for public to work on, I would say, and third thing is, I wouldn't hold any one person responsible. I think we are all collectively responsible, and which is why at least I try and tell that the role of architects is no longer now on the drawing boards, but it's also about bringing subjects of public advocacy in public domain. We should perhaps be doing workshops in public spaces, talking about all this in that domain is where it is. The fourth perspective on this accessibility I want to bring here is a notion that accessibility is all hard. It means it's hard paved surfaces. It means hard paved buildings. It means everything that is visible. No, I think accessibility starts with the invisible, which is about information. When I plan a trip to a public space, do I even know where to get down? Will that space be accessible? Will there be a washroom near to me? So I think the first we have to start working on is the invisible elements of public space, which starts with information accessibility. The second is the visible side of accessibility, where we have to then ask a question, for whom are we asking? The biggest mistake, or you can say oversight, which has happened in our profession is that we assumed blindly for almost many years that we are always designing for a fit individual who is absolutely 5 feet 8 inches tall, wears perfect shoes, has enough money in the pocket, and is absolutely well-to-do person who has a bike, who has a car, and will have a parking space. So we have always considered that average. And I would say that assumption of an average has been the biggest anomaly in design, because then that is where we start talking about public space for the non-average. And when you start talking about the non-average curve of India, you start realizing the social inequity, the social imbalances, along with the balances of functional inabilities that we have in our population. So it's not about whether I am fit or not. The question is, at any given time, I could also be in that position. And that realization, I think, both not only our community, but also people who are on the implementing side, it doesn't require big educations or degrees. It requires only one word: sensitization. And I still believe...
Yeah, please carry on. Yeah.
So that is one conversation which I definitely always enjoy, that, I could never find in my past so many years of work one reason why we should not be doing accessibility, while we see so many examples of not being accessible, but why it is not. And my last point here is, is a debate where many a times, even before we spark off these conversations on accessibility, it is closed down by one word called cost. Now, here I want to make a small correction here. There are three very similar words. I am not an economist either, but under the domain of economics, I see these three words. There is one word called cost. There is a second word that is called price. And there is a third word which is called value, right? I would say, do we realize the cost that we are paying for making stuff inaccessible? And if I give you simple statistics by any logic, even if I haven't done a personal survey, at least 40% of the country's population you can group in a category called dependent population. Now, if that dependent population cannot access an ecosystem which is built environment, that 40% cannot contribute to your economy.
True. In fact, my follow-up question to this was exactly this, in the sense that do you feel that inadequate public amenities can actually be a stumbling block in the growth and development of our country? So I was about to ask you this question as well.
Sure. I think, yes, if the debate carries on this further, it's pretty clear, First of all, we have to revisit what we mean by development. Because I think there are paradoxes even on that notion. Does development purely mean industrialization, or does development mean development of human values? What kind of society would we want to live in? And that is where I think even when you come to judiciary, the question arises is, why do we have more conflicts in society? Besides on one side, we talk about more demand for judiciaries and judges, is also a kind of indicator that the society is going through rising number of conflicts and lesser number of consensus. And that is where I think the debate brings us back to is development in a conflicting society will definitely have a retardation rather than an acceleration, versus a society which has mutual consensus, mutual agreement on commonly human values. Accessibility to me is a common human value. And if I could paraphrase it, going back to the corollary which says justice delayed is justice denied, I would say accessibility delayed is life denied. If I do not give you access to water, what will happen? Access to sanitation, and there are plenty of cases that we know that you did not have access to sanitation, therefore girls dropped out of schools. Now, because you didn't have access to sanitation, your access to education became a compromise, and that led to access to employment. Eventually, you became a person confined to four walls, and the society started reverse looking back at you as a burden, whereas it wasn't anywhere your fault. So I would say, this perspective I would bring, and the last point to add here is that therefore there is immense value in this idea of accessibility. It is not a special thing. It is a given thing, must be part of any system. And therefore we can look at it at three levels, even in public spaces and built environment. One is at the level of information. Second is at the level of, I use a word, built infrastructure. And third, at the level of, I would use a word, is service infrastructure.
Okay, right. So moving on to Justice Sikri, actually, I think we have the most hard-hitting questions for you, sir. When we speak about judicial reforms, and as Reshma pointed out, the common discourse is usually either around the lack of judges, sufficient judges, or pendency. Unfortunately, there is hardly any deliberation over the dilapidated judicial infrastructure. I think Vidhi's survey is kind of a pioneer in this aspect, and trial court being the first point of interaction for a litigant. Yet, this part of the judicial hierarchy has been neglected for several years. Hardly any effort is made to kind of augment the basic facilities and services in the court buildings. So, why is it so, sir? Of course, we are now seeing conversations building up around this subject, but why is it that for so many years, judiciary has not really taken care of something called the subordinate judiciary?
You see, I think you have made a very valid point, and what I would say that the statement which you have made may not be entirely correct, but substantially correct. Of course, we talk of the reforms in the judicial system, and when we talk of reforms in the judicial system, main emphasis, as you have pointed out, is on increasing the number of judges, and how to have automation, how to have court management and case management, so that, and it includes even computerization, etc. as well. So no doubt the main emphasis is on this. But let me tell you, it's not that as far as infrastructure is concerned or court buildings are concerned, these are always put at the back burner. Maybe in the priority list, it comes at the bottom, but at the same time, it has been in the, within the vision of the judiciary also when we talk of judicial reforms. But the kind of the priority or the kind of importance which should be given has not been given. There you are right. I look at the matter from another angle, and almost same thing which Mr. Raheja has said, and Reshma has also highlighted in the context of the infrastructure in the court system. Mr. Raheja has discussed generally about the public buildings and their importance, and how the architecture should be seen in the today's time, and how it is mainly we have the interest in the life of the person, or the persons who are it's not the brick and mortar kind of structure which is to be created. In the context of judiciary, I look at it from the angle of which he said about access. I say access to justice.
Right.
When we talk of access to justice, then again we take a myopic view normally, that access to justice is that, yes, I'm able to approach the court of law, file my case, and get the order and get the judgment, which should be cost effective, and it should be as speedily as possible. So we talk of access to justice in that form. And when we talk of access to justice, therefore we give credence to or importance to even the legal aid, etc., that those belonging to marginalized section of the society, or those who are poor, not able to have access to courts in that sense, so therefore they should be given legal aid. So the importance is attached to legal aid also, so that they are able to approach the court. But when they approach the court, that is only one side. The second side which we are discussing is equally important. Access to justice. When we talk of access to court, first thing is access to court building and courtroom, and creating a congenial atmosphere there in the courtroom becomes very, very important. And we have to keep in mind here the two aspects. Number one, courts are meant for litigants. They are the consumers of justice. It is they who come to the court to seek justice. So therefore, courts are here to serve the litigants. And I have always, believed that the courts are there to serve the people, and we are not the masters. And so therefore, our job there is to serve, and of course, in the process to do social justice and all other things. But I'm eschewing that kind of discussion for time being. That is not relevant. But so therefore, consumers of justice or the litigants should be given prime importance, which in our legal system we don't give. It is not in our system only, and I have seen in other countries as well. Sometimes I tell you very interestingly, there was one study maybe about 20, 25 years ago in England. They talked, they had interviewed the people who were visiting the courts, that what is your experience? Those who are the litigant and who go, they may go as witness, they may go as litigants, etc., in whatever form. And the expressions were daunting, apprehending, intimidating,
Yes.
fearful. Now, these are the expressions used. I still remember that report, having studied that report more than 15 years ago. So when we are talking of giving access to justice or giving justice to these people, and if they have got this kind of experience, even in England, most of that, and India, it may be still worse. So therefore, is it not our duty or the duty in the judicial system that when the litigants visit, not only in the courtroom, that they are made comfortable while dealing with their cases, whether it is at the hand of judge, because judge also should, when we talk of intimidating, it is not only the infrastructure, etc., that is included, but behavior of judge and the court staff is also included. I include that as well.
Of course, of course.
But since we are talking about infrastructure, it is not our duty then, or duty of the judicial system or legal system, to make them comfortable. Therefore, what Reshma said about in the courtroom, whether accessibility to the persons who are handicapped, women. We have been talking about crushes for women lawyers. So women, when we talk, I include women lawyers also who visit there. Yes. Then the sitting space for them, the water and sanitation facilities. She talked about the washrooms, etc. So all these are, what I feel is that if not a 5-star standard, at least 3-star hotel standard, and those kind of facilities which are which may be only comforts, the necessary comfort and the essential comforts, that is to be provided.
Yes. Sir, I would just like to add in over here. See, when we talk about judicial infrastructure, we only keep the litigants in mind. But for me, something which is very close to my heart is, women lawyers. I think in the field of litigation, we have...
Coming to that.
Right, yeah.
I said that two sides. One is we have to cater to the litigant. They are the consumers of justice. Other, I was not talking about the stakeholder, or rather the players in this justice system. That is judges, staff, and the lawyers.
Yeah.
Of course, comfort level is necessary for judges also when they sit in the court. We have seen to forget about Delhi and some other metropolitan cities, etc., in small towns, sometimes a court, there was no space, and in a washroom, courtroom is created. Yeah. Sometimes in some parks, outside courtroom is created. A person is sitting in the lawns, and because that judge doesn't have any infrastructure. Right. There are not even proper tables or furniture or the stationery given to the judges or the staff. Right. So we have on the other side that kind of picture as well. So how you expect efficiency from the judges and from the court staff unless they are given a proper environment, a working environment? So therefore, and likewise when the lawyers come there, for lawyers also, why we talk of lawyers, and I remember it was whether it is part of the legal system that it is necessary to have chambers. There was a debate a few years ago when I was in the High Court about 12, 13 years ago. If you see in Delhi, almost whether it is Supreme Court or High Court, where it had always been there, but even the district courts which are created, there are chamber blocks which are all constructed. So there was a debate at one point of time about 15 years ago, whether it is necessary for the courts to provide chambers, because they are not in a way the employees of the court. They are having their own earnings, so they can earn and they can then spend upon wherever they want to have their offices. But then it was, the conclusion of the debate was and I also fought for it. No, in a it should be treated as a part of rule of law, a part of essential element of the justice delivery system, that in the infrastructure we have to have proper facilities for lawyers, which include chambers. And here, when you say about women lawyers, they become a special and a class in it by themselves. Because in the High Court, I remember about maybe 12, 13 years ago, there was discussion why there should not be crash for women lawyers. Because there are many women lawyers, young lawyers, who may not have now with the nucleus families, etc., may not have anybody to look after. Now, not that each and every woman lawyer can afford nannies who take care of their kids. So why not? And that may be one of the reasons that many times women lawyers come, and after marriage, and when particularly after their children, they have to leave the profession. If not for some, if not forever, at least for a few years, there is a gap. So therefore, and I look it from, again, I go back to that, look it from the angle of access to justice. So infrastructure is an essential, integral part of access to justice, and we have to give due importance, which you rightly said that, yeah, when we talk of reforms, we may be giving more importance to other factors, but this is equally important along with other factors. And the way Mr. Heja has explained so beautifully about the importance of these buildings, that makes it makes a very, very strong case for proper infrastructure of the as well as the court buildings are concerned.
Right. So hopefully, with the present Chief Justice of India mooting the proposal of a National Judicial Infrastructure Corporation, I mean, we can hope for the best, and actually, just hope that the infrastructure of the subordinate judiciary is augmented with time, and there is no opposition from the government, both the center and the state. Moving ahead, Vidhi, I just want to ask you one thing. Vidhi has been instrumental in drafting the guidelines for live telecast of court proceedings, and has also worked to mainstream the online dispute resolution in India, So do you view that NJIC as a panacea for all the problems, or do you think that there should be a parallel mechanism to also adopt technology for a better and a faster access to justice? Because we have seen that, during the COVID pandemic, actually, honestly, I think the COVID pandemic provided the much needed impetus for a change in the judiciary. Judiciary went on to adopt technology. It moved from offline hearings to online functioning, which was a very welcome move, considering judiciary has been traditionally opposed to the idea of a live telecast. So how do you view all this, and what has your study revealed? And do you think people are ready to adopt this transition?
Yeah, thanks, Bhadra. I think one important way to answer this question is to take a step back. And I think especially in light of COVID, there is this inherent belief that all technology is good and technology is here to solve all problems. And to some extent, that statement is right. It can make things better. But I think the subcomponents of the question that you asked, which is one, live streaming, and then there is ODR, there's also physical hearings. All of them are different aspects of how technology has been integrated into the justice system. And because they are different aspects, the way that we need to understand and deal with them also needs to necessarily be different. So live streaming, for instance, has been, the move has been there since 2018, where Sahnuti Party was given. And then, it was really driven from Article 19, which is the right to free speech.
Right.
And there are so many benefits to having live streaming of proceedings. I mean, it increases, legal education for students. It also increases accountability of both the bar and the bench. For individuals who want to represent themselves, it allows for self-representation. I mean, there are many, many benefits to it, and all of that has been very definitely recognized. But how live streaming of proceedings is going to be introduced also needs to some extent be incremental, because there are other rights in place as well. There needs to be restrictions so that there is protection of privacy. So the manner in which we deal with this also needs to be articulated in the context of open data vis-a-vis privacy principles.
True.
Right? And I think that balance needs to be struck. Now, when we go to physical hearings, on the other hand, there is another balance that needs to be struck. So of course, because of COVID, physical hearings, online hearings were it really was the lifeline of how courts were able to function. But there is enough conversation, and the Supreme Court Bar Association has been talking about this for a very long time, that junior lawyers particularly have been impacted. Senior advocates have been able to really benefit it. They have been able to, like, court hop, for instance, do hearings in Madras High Court and then do it in the Orissa High Court, do one in the Supreme Court. So there is a lot of benefit that they're able to accrue from it. And there are positives. It has also provided a lot of litigants opportunities for their cases to be heard. Otherwise, they might have not been. But on the other hand, there are also junior lawyers who really have lost jobs. The disparity in the Supreme Court, for instance, some of the data that Vidhi had worked on says that 50% of the cases, as far as AOR filings are concerned, are done by 7% of the ARs, and 93% of them are done by the remaining. So basically 7% is doing the work of 93. So there is an inherent disparity that exists. So and I think that's why there is a push for having physical hearing. So that's another balance that needs to be played. And third, which is the ODR aspect, there is another balance that needs to be played as well. And that really arises. ODR, for instance, is not necessarily, when we think about it, it's online dispute resolution. So it becomes a mechanism of resolving disputes outside the court mechanism. It can be done in multiple ways. I mean, courts can be associated with ODR. They have mediation centers. You can also use the private sector to resolve cases under ODR. But over here also, we need to think about how it can be mainstreamed. It can't necessarily be completely without regulation, because there are a lot of entrants into the market. It also addresses a lot of rights of individuals, because now you are in some form delegating some aspect of a justice delivery. So there needs to be some thought process behind how we can maintain due process, how it can be fair. And so there is another balancing aspect. And I think especially when we are looking at all of these technology related solutions, we have to necessarily keep in mind, whether it's AI or any of these, that India does function where there is an extremely high digital divide. And at the back of our minds, when we're trying to introduce these technology interventions and innovations, all of them have immense promise. We need to be coming from this aspect, that how can we ensure that all the vulnerable sections that really don't have access to these technology means, how are we bringing them along in our journey of increasing efficiency? Because ultimately, if you're talking about access to justice and justice delivery, there is a large section that will otherwise be excluded. So I think that, thinking about in terms of balancing and inherent problems of current status quo, I think is something that we need to necessarily keep in mind moving forward, even though technology has so much promise.
Yeah, so I wanted to ask Justice Sikri exactly this question. Of course, sir, you headed a committee that has suggested a legal framework to back the ODR mechanism. But, considering the digital divide in our country, which actually got exposed during the COVID pandemic, we actually saw how many lawyers really lost their livelihoods because either they were not well equipped with technology or the judicial forums were not well equipped with technology. So, how does one really overcome these practical difficulties where we are still challenging with our bandwidth problems? All of us know that in our daily hearings, even in the Supreme Court, every day there is some technical glitch or the other. So these are basic practical difficulties which we are really looking at.
Yeah, you are very right. Actually, if you see COVID, pandemic has taught us the use of technology. There's no doubt about it. I always, as I said earlier also, and generally also, I say that when there was lockdown and other things, and if you remember, the government, and it had to be, that government exempted essential services.
Yeah.
Of course, because without that you can't live. You can't unless you have everyday grocery, milk, etc., and other things, medicines. Include legal system or providing justice in that category. So because of such, this pandemic situations, you can't have a situation where the courts are closed, shut totally.
Sure.
So therefore, in a way, of course, for last 20 years, there had been some discussion about automation, technology, and how it can improve our justice delivery system. But COVID taught us that it was from automation to transformation insofar as legal system is concerned, and how it has to be imbibed and how it is essential. And it happened not only in India, but throughout the world. Not only in court system, but all kinds of ADR also, whether it is mediation, whether it is arbitration. So last 1.5 years, I'm doing arbitration, online arbitration, totally. As you know, I'm the judge of Singapore International Commercial Court. Even today, we are doing those court cases. So there's one judge sitting from England, one judge sitting in Singapore in the courtroom, even when it is physical in court, suppose on those times, and one judge sitting from India, and we are doing those cases, and even the parties are from outside. So it has this kind of technology has helped a lot insofar as judicial system is concerned. There's one, I'll tell both Reshma and Vedehi to read that one book of Susskind, I think Richard Susskind, Future of Law, and he says Future of Courts. And he says how technologies and artificial intelligence, etc., are going to totally change this world. Now, on the one hand, it is becoming important that without this digitalization, we cannot go ahead, particularly when we have to meet these kind of situations. And I would here include when we talk of globalization, we talk of ease of business, and we have our commercial litigation and international litigation, where we have to send a signal to the world at large that look, because the courts are not going to be closed, and the courts will function as efficiently as they can in normal circumstances during this period also. So all this makes technology as essential attribute.
Right.
There's no doubt. But on the other hand, you rightly said, and Vedehi also pointed out, digital divide which is there. Now, while doing this, this ODR report, we saw here, and it is captured in the report also, Reshmi knows it, that what kind of challenges which are going to be faced in ODR, which would include to some extent online, even when we talk of courts, etc. also.
Right.
One is structural challenges. Now, structural challenges are digital infrastructure. We have to have proper infrastructure. As you rightly mentioned, the glitches we find even now in courts hearings sometimes. We have to have digital literacy. There are many, we can't only talk of those young generation from national law schools who come and they are techno savvy. But the digital literacy is required for everybody, and everybody who is the user of the system. Now, my knowledge of this computerization and technology, use of technology has increased substantially in this 1.5 years, because I have to compulsorily now use this system. But then there are many, we have advocates in mufassils, we have advocates in villages, small towns, etc. Those, because this kind of challenge has been faced even in the schools, where the online schools are there, but how many there are dropouts. So likewise, there are many advocates, they don't have iPads or computers with them. They can't join online. So therefore, and even if they buy, they are not, so digital literacy is not there. So that is to be there. Then divide in access to technology, as I mentioned. So these are structural challenges. Then second was behavioral challenges that you have seen. People, there are many was, sorry, we are not going to do this online. And there is another breed which has developed now of the advocates only, that after taking advantage or after finding advantage of this technology and online, and we have some, advocates who can sit on one chair and appear in 4 high courts and Supreme Court at the same time, which was impossible. So they want to continue with this kind of system only. Right. And we know one, everybody knows Mr. Harish Salve sitting in London is appearing in all the courts every day in India. True. So therefore, this behavior challenge is also there, where there's a lack of awareness about it, lack of trust in the system, legal culture, and role of government and PSUs. This I am talking in the context of ODR. So therefore, how far, how much acceptability is there? Of course, in the report we had, talked to about 7-8 ministries which are relevant, and we have found encouraging response from there. They have given their feedback also, which has all been now incorporated in the report. But then let us see. Saying all this is easy, as you said about the infrastructure commission, which the Honorable Chief Justice has also mentioned. It's good, but the challenge lies in walk the talk. So therefore, how much steps are going to be taken in this direction, and therefore that would be challenge. And third challenge, which we have mentioned in that report, is operational challenges. That is privacy and confidentiality concerns which may arise in the process, because if when it comes to particularly mediation, and mediation has to be all confidential. In the arbitration also, confidentiality is one of the attributes. Therefore, the two parties may be knowing, but confidentiality clause is there that it will not be telling. And that is one reason that many times commercial disputes or maybe family disputes, they want arbitration so that everything doesn't become public. Of course, it may become public once the award is challenged and the court proceedings come, then things become public. But privacy challenges are there, confidentiality concerns are there. Then so therefore, when we talk of these things, there are some other challenges. If we come to only ODR, that is availability of the neutrals who would be there, and we have archaic legal processes and enforcement of outcome of ODR. So those challenges are there. But question is only this, that merely because there are challenges, that doesn't mean that we should not take that road ahead. And we should not go into that. But yes, in the beginning, now we have to, so therefore we have two sides. On the one hand, we have seen the benefits of technology. We have seen that how it can work, and that is why there is a discussion that even after we returns to the old normals, although this is called new normal, this pandemic, so old normals also, and even if when the physical hearing start or in-person hearing start, it should be a hybrid system. And in any case, what I feel is that in certain circumstances, use of technology and online hearing would always be more beneficial. Like suppose you have one today, even in court case, arbitration, it happens every day in court case. One witness is in England or in Bombay. In Delhi, the case is there. Is it, if that witness can be examined online, why they should all come to Delhi and appear in the court, and whether court case reaches or doesn't reach, and next day, and they're waiting for maybe one day hearing, they're waiting for 10 days and staying in the hotel, the cost which is incurred, ultimately that all can be saved, time can be saved. So therefore there are many advantages, and therefore we should face these challenges. We should try to, like with the digital divide is there, we should try to see how to bridge that gap or bridge that divide. We have to have more infrastructure created, and that infrastructure court, when we are talking of infrastructure, now all future courts, or rather we used to call them as future courts, this is now in present time, it is not future now. So therefore, they have to be equipped with all these kinds of infrastructure. I tell you, in 2018, it was May or June 2018, I had gone to, it was Chief Justice's conference, or SCO, the Shanghai Cooperation Organization, which is there, and there's 6 or 8 countries who are the members, including India, of this, which China had started at that time, I think 10-15 years ago, and India and Pakistan became member about 6-7 years ago, and therefore they have prime ministers conference, then I think maybe foreign ministers also, and chief justice. Many people don't know the SCO, prime minister, etc. It happened a few days ago only, but there's always chief justice's conference also all this year. So that year chief justice sent me and 2 more judges of the Supreme Court. We had gone there. I tell you now, China, if you see 25 years ago, there was hardly any judicial system. If they have come out with, because of globalization, becoming part of global economy, etc., they have to have courts. And the infrastructure, I was amazed to see, which is not even needed today. they are thinking of 50 years hence.
Yeah.
And they have all courts inside which are online. I mean, in the court, you will find big screen. And online, if the parties want, even if suppose some family dispute between two spouses, and if they want, they can join from different places in China and in that particular district court. And the court building where I found 5 or 6 storied building with all kinds of infrastructure, all kind of facilities were there, although they were not using it. Hardly, I mean, 10% or 15 or 20% of it was in use, but the thought of 50
But the setup was there. But the setup
was there. All that setup, and including AI in writing judgment, they have started making use of artificial intelligence. So therefore, I say that they are thinking on future, but today it is not future; it is present. We have to have it today, and so therefore, the judiciary and government has to come together. Because as far as judiciary is concerned, we know somebody said it's in 70s that Nickel, what is his full name, wrote a very nice book on the least dangerous branch about American judicial system, American court. Why out of the 3 limbs of the state, the judiciary, executive, and legislature, judiciary is the least dangerous branch because it neither has purse nor has sword. That is what is said. And so purse, here we are talking of purse, we are talking of money. That is all with the government. So therefore, government has to give full cooperation. When we and I'll say that government, for its own selfish benefits, when they talk of ease of doing business, when they talk of Atmanirbhar Bharat, etc., when they talk of 5 trillion economy, all this is, I mean, the robust judicial system becomes important in achieving all this.
Before I end this discussion, I want to ask a question from Professor Raheja. You know, we, of course, the second part of the discussion was, you know, it focused on the online platform, the online mechanism. But don't you think that this would also require some sort of special infrastructure? Because after all, you know, we have differently abled lawyers in the legal profession. We have differently abled litigants also. So how do you see this? How do you view the state's role over here? What kind of a special infrastructure do we really need to build in to make it a more inclusive ecosystem, even if online is adopted?
Thank you, Badra, for that question, and very nice discussion here by all the panelists, and very valued points with Justice Sikri as well. In order to respond to the idea of this online, again, I want to, you know, on a slightly philosophical note, if you allow, I want to bring back the pyramid of Maslow's hierarchy of needs, you know. It always starts first with physiological. Because what has happened is, you know, in a digital space, there have been certain set of assumptions, which I presume sometimes are not true or are given. For example, do you see a computer or a digital device without sitting on a chair? I mean, even chair is a part of infrastructure. And you know, how long can you sit on a chair? I'm pretty sure while COVID has taught us a lot in technology, I'm sure 5 years down the line, you see the health data of physiological disorders that are going to emerge is going to be another one side. The second thing is, you know, your computers, your digital devices run on batteries and they emit heat. There is a heating instrumentation here. And I'm presuming, again, without a study here, there must have been an increased demand of air conditioning.
Sure.
Right? Now, isn't that an infrastructure? Doesn't that electricity require, because your housing facilities in India still sometimes run on backup power backups versus certain office systems which are a better maybe supply system and they could be taken care of as an infrastructure. But now this has to be part of a residential infrastructure when you call it work from home. The third level, I would say, so one is the basic interior furnishings, etc. And a very important thing in an online system, which I think still remains an ignored dimension, and I can tell you because we are taking online classes as well, that is the need for acoustics. To be heard, you need to have an environment in which you can hear. right? And with the noisy context of our urban streets, with the noisy context of where we are living, I think that has become a real big challenge. When how do you manage, the online services? And paradoxically, lately I realized that the word listen and silence have the same characters, just just played in a different way. So if you look at online infrastructure, it needs many other services which have to house it. And at the last of all this, you still need a roof. Can you look at a screen without a dark space? And paradoxically, again, many years ago, we used to say education is enlightenment and it's about light. And now every morning when we take a class, we first convert it into a dark room so that we're able to see the digital screens. Right. So even that infrastructure, which allows you to manage and operate daylight, which can illuminate you sufficiently, provide you power services, provide you freedom to move anywhere, which means you need even tables of a certain kind, which are flexibly arrangeable. And in all these cases, frankly speaking, if I can just use one word, design is something which is becoming underplay everywhere. But sadly, I think it's been devalued because we again become like do it yourself, and then we mess it up in the way we already are.
Well, thank you so much. I'll have to wrap up today's session. I'm extremely grateful to all the panelists who took out time to participate in this talk and, shed light on an aspect that is hardly talked about in the context of judiciary. And as for the viewers, I thank you all on behalf of the Print and Vidhi Centre for Legal Policy for joining in and urge you all to look out for the remaining sessions of the series. Thank you so much. Thanks a lot.
Thank you, Badra.
Thanks.